Good afternoon to all attendees tuning in from Malaysia and the region, and good morning to all our attendees in the UK. I hope everyone is keeping safe and well. I'm Tian from Membership and Strategic Partnership Department at the British Malaysian Chamber of Commerce, Berhad. And welcome to the BMCC webinar on conducting effective and professional internal investigations in collaboration with Key Risk Consulting Asia, Sendirian Berhad. And today's session will be presented by experts with significant internal investigation and legal experience, intended to assist cooperation in understanding the fundamental principles of conducting internal investigations, establishing an investigation structure and levels of responsibility within the organization, and ensuring compliance with legal and ethical standards, as well as employee labor rights. It is also a great pleasure to have Ashok Sarangapani, the Strategic Consultant of Corporate Governance, Finance and Anti-Bribery Management Coordinator, and Christina Wang, the Legal Advisor and Project Leader in China of Key Risk Consulting Asia, as well as a Senior Partner at Universal Law Office to join us today as panelists. Just to share some housekeeping reminders, and please feel free to ask your questions and send them through the Q&A chat feature at the bottom of your screen. And we will attempt to address your questions during the Q&A session if time permits. And before going into the panel session, we are honored to have with us today Robert Youill, the founder and executive director of Key Risk Consulting Asia and Key Risk Training Solution. Robert is a highly qualified and experienced risk and investigations expert with over 40 years of senior level experience in investigations and risk consulting. He has extensive expertise in corporate strategies for the protection of intellectual property fraud and corruption investigations, asset searching, supply chain integrity, commercial theft, due diligence assignments, as well as designing corporate internal investigation strategies and complex case management. And without further ado, I would like to invite the man of the hour, Robert Youill, to deliver his presentation. Over to you, Robert.
Thank you very much, and a warm welcome to everybody. It's good afternoon to some of you and good morning to others. Welcome to this session, which I hope you're going to find very informative and entertaining. A little bit further to the introduction of myself, apart from being in the corporate risk mitigation business with Key Risk Consulting Asia as the founder, I was also a police officer in Hong Kong for 20 years, where I was a senior detective, and I mostly investigate organized crime. So investigations are very much part of the DNA for me, I'm afraid. So today's presentation is going to be very heavily weighted towards that kind of mindset. And hopefully I'm going to be able to give you, along with my two panelists, some good examples to help illustrate the points we're going to be dealing with today. So without further ado, I'm going to share the screen and I'm going to start the PowerPoint presentation. And then we're going to cut from that into the panel discussion and then into your questions. So bear with me while we just get the share screen on. Okay. Now, as mentioned, as the title says, this is actually a 1-hour session relating to conducting corporate internal investigations. And what we're going to be dealing with here is we get the PowerPoint up and running as soon as we can. Then we should be able to go into, yes, thank you. I got my technical assistant aiding me here. Basically, what this is about really is what keeps you up at night in corporations and business when it comes to misconduct of employees. In this day and age, many employees understand their rights, understand what they can and cannot have from their employer, what they're expected from their employer. And employers very much have to face more of a minefield than ever before to navigate things like labor tribunals, civil suits, et cetera, by employees who think they've been done wrong by. And every day you see headlines of employees suing their employer or taking them to court in some civil suit somewhere. Invariably, what happens, of course, is we have a degree of misconduct, and then some form of internal investigation is usually conducted by the company, and then that leads to dismissal of the employee concerned. The issue simply is that whilst many companies have policies, procedures in place covering ethics, compliance, conduct, etc., When it comes to the actual investigation proper, there's issues that have to be dealt with that they have never ever come across before. And if you get this wrong, you could end up in all forms of problems for your company. So what this presentation about today is trying to help you and guide you and give you some ideas of what you can do to help your organization be better prepared for when you have to investigate misconduct of an employee. And when I say misconduct, I mean, I'm not just talking about properly in terms of showing up for work contact, etc. I'm talking right the way through to major fraud, corruption, bribery, and serious criminal activity that employees do get involved in within their organizations. So basically what this presentation is about for you folks today is trying to help you be prepared for that issue when it arises. And what I want to start off with is discovery of misconduct. And basically, there are many ways in which misconduct in legal activity is discovered when we're dealing with employees. And these include, and we found this from our work as consultants and doing investigations for corporations. We find, for example, customers come to you and complain about errors in statements, delivery documents, or whatever. When you take a look at them, you found out there's something definitely wrong here, and there's an investigation that's required to find out what's gone wrong. By accident, and this is not an uncommon one in our world, a supposed customer, supplier, employee is found to be fake. Documents have been produced that are going through procurement or going through accounting, and there's no fundamental control over them, and there's no substance to what's on those documents. Attempted rewriting or overwriting of documents, delivery documents, shipping documents, etc., are another way that this discovery of misconduct comes about. This is from our experience, of course. This is a very common one, following the departure of an employee or a group of employees. Many of the cases we've dealt with over the years, we've been called in to take over investigations, and we found out that the head of finance has left, or the head of procurement has left. And when the new person has come in and started to bed down into the company, they've discovered things in the bottom drawer that weren't there when the person left. They're hidden. And I'll show you a case example of this later on. So it's when we've had a departure, and usually it's departure of someone reasonably senior or management level within the business. Routine internal audit. Many companies conduct their own internal audits these days. This is one way in which malpractice surfaces. However, the popular belief is actually not correct. A lot of companies, a lot of people that we talk to within corporations believe that the annual audit, the statutory audit, will actually reveal misconduct and illegality of their employees. This is not actually true. This is not actually true at all. What we do find, though, is that vast majority of this in this region, Asia, the vast majority of misconduct and illegality is actually discovered through what we call whistleblowers. Everyone knows that term. Anonymous letter to the CEO, anonymous email, or a call to an ethics hotline. So in our experience, whilst all the above do lead to identification or discovery of misconduct, the last one, the ethics hotline, the complaint hotline, the anonymous tip-off, invariably is the way that the vast majority of serious misconduct actually is uncovered. And later on during the panel discussion, Ashok is a bit of an expert on whistleblower hotlines through his work within corporations around Africa, Middle East, and this part of the world. And we'll have a little talk with him later, and he'll explain how important a whistleblower stroke hotline to help your investigations kick off on the right path. One of the issues that management are concerned about, in our experience, one of the most important ones, of course, is the money impact. And we're talking about serious misconduct. When I say fraud, theft, large theft, bribery, corruption, this type of thing. Normally, management's concerns start off with how much is this costing us? What is the loss? Second one, though, should come straight out of the box. We want to know who's involved. How deep does this go? Where does the accountability lie? Next one out of the box. How was this committed? I would say the modus operandi. How did it occur? What led to this misconduct, this activity taking place? Next question. can we recover the losses? If this has been a substantial fraud, a substantial supply chain diversion, how can we A, stop it? And how can we B, stop the losses and recover the losses? And this could involve insurance, of course, but it can involve, shutting down activity within the company in order to stop the losses while the investigation commences. But this is a major question. This is another major question. How do we keep it under wraps? And this is an open debate here. We've done all kinds of investigations where, in some instances, the CEO demands that it's an overt investigation immediately to send a message to the employees that something has gone wrong and we're not tolerating it, versus the company doesn't want anybody to know about it because it could be a life-threatening, or sorry, a corporate-threatening, enterprise-threatening activity, and we don't want this to get into the public domain. So the debate rages on this one right from the get-go, and every case is unique. So every reasoning what to do is unique. Normally, most folks will go for, let's keep it under wraps until we know the extent of the problem, the extent of the damage to the organization. And it's also very important, of course, because we tend to advocate this approach simply because we don't want evidence to get lost. We don't want the perpetrators to be tipped off, witnesses to be got to, etc. And it does happen. And I will give you a case example shortly to illustrate that. Next question management want to know: is there a requirement to report to regulators? If you're a listed company and you've had an act of bribery or corruption affect your business and you're a listed company, then you're obliged under certain rules and regulations, FCPA, UK Bribery Act, etc., to report to the regulators the incident itself. How much time you have for that under most legislation is not dictated, but it's usually as soon as reasonably practical. Another decision has to be made. Personally, I've done cases, particularly in China, where a US corporation has kept it under wraps for far too long and has incurred the wrath of the regulators for doing so, and was fined heavily for that reason. Again, should a report be made to law enforcement? If we're dealing with serious misconduct, which could be criminal in nature, should we call in law enforcement straight away? Most will not do that, and we would tend to advocate that unless it's an enterprise-threatening activity, or it's an outside gang or an outside influence that's doing something that needs to be stopped. But here we're talking about employees, internal. So should we report to law enforcement? Eventually, yes, I suppose. You're going to have to, it's a crime. But immediately, maybe not until you've answered those questions above. But it can't take forever, obviously. But generally, for example, if again, looking at China, for the work we did there, if you report to the Public Security Bureau, you believe you've been defrauded, and you make a serious complaint and demand action to be taken, you will very quickly lose control of the investigation. They will take it over. Very often, a fishing expedition will commence for evidence of the fraud and evidence of malpractices within your business. Do you want that? Probably not. It's a judgment call, but it's something that management must seriously consider when an incident is discovered. The reason, because each of these issues and concerns will definitely have some level of impact on how the corporation, the company, sets up its investigation plan and executes that plan. Those questions need to be answered. Without answering those questions, you cannot formulate a plan of action. I'll give you a case example of how it can go wrong. This was an actual case we did about 2 years ago. It was a US company. Its trade was to make customized furniture through 5 factories in China. They had a Shanghai-based business, locally operated. Orders came in, furniture was made to order, shipped to the US, and went into the market. And it was very high quality furniture. One day, they had a complaint. They didn't have a proper hotline set up, but there was a letter written to the CEO in the US that the managing director of the company was living beyond his means. Not much information was given in the actual letter of complaint, but it was sufficient for the CEO and his number 2 to jump on a plane from the US, fly to Shanghai, and immediately start an investigation of the general manager. He wanted to keep it under wraps, so we started the investigation. And the first thing he did, he went straight into the general manager's office, banged on the table and said, "Tell me all about it. Why are you doing this?" Wrong. Definitely wrong. Not the right approach. He then set about trying to recover the laptop computer that the general manager was using, which he kept in his home and never brought to work, but which he believed contained evidence of his activities. Bearing in mind, no one had yet approached the whistleblower to find out what the activities were, but they decided that they had to act upon it. He then asked his number two to go round to the general manager's office, home, and get the computer back, not wondering whether the computer itself was owned by the general manager or owned by the company. Well, immediately that's an illegal act with anyone's book. But this is how emotional, and it's important to remember this, how emotionally this fella got involved in the case and decided to run it himself. Eventually, the general manager didn't come back into work the next day and disappeared. So we got called in to do the job, and we came in and we spoke to the secretary, who we found out was the whistleblower, and asked her and debriefed her at length what the issues were. And basically what the issues were, that the general manager was actually going to each of the 6 manufacturing companies that were making the furniture and persuading the owner of the companies to fail the product quality inspections of the furniture. And those that failed were moved to one side and kept so that the general manager's wife could open her own online business and sell the furniture cheaper, thereby competing with our client. So we went into the office, did all the work as we should have from the very beginning. And this is what we found in his office. We found out from the secretary that he'd recently had a new wardrobe built into his office. For no reason, company paid for it, but he needed a wardrobe for his office. When we looked at the wardrobe, we noticed hinges were on the outside of the wardrobe as well as on the inside. As you can see from the images, we rolled it open, and what did we find behind it? All the ledgers and books that he was keeping for his wife's company, the failed furniture that had been sold off to his wife to sell online. This was all the evidence we needed, except for the fact he shredded a great deal of the evidence. Why? Because the general manager, the CEO that came in from the US, had gone in there straight away and tipped him off by interviewing him what the case was all about. So he started destroying the evidence. So inside that wardrobe, inside the boxes, were bagfuls of invoices, etc., that had been shredded. It took us many hours, I can tell you, to put it all back together again. And eventually we found out who the wife's customers were and the fact he was part of the business, and how many other entities were actually involved in this incident. The reason I give this illustration is for several reasons. One, we'll be drawing upon this example later on when we talk to Christine and Ashok. But secondly is just to illustrate how a simple little allegation can grow very quickly into an enterprise-threatening activity. And third, how emotion and leaping in there straight away with no plan can lead to disaster. Eventually, they did pass the case to the law enforcement, and this gentleman was arrested for defrauding and bribery of the company. But that just gives you, we've got lots of examples like that, but that just gives you a taste of what it's all about. And what it is all about is, as Winston Churchill said, he who fails to plan is planning to fail. So what we're going to talk about now briefly is investigation planning. How does it work? What should you be doing? And the first thing is, don't wait for an action to start. Don't wait for a serious misconduct to start. Don't wait for that fraud to be found out. Don't wait for that corrupt activity to be discovered or reported. Set up the dream team at the now, before it happens. And the dream team must be staffed, if you like, by numerous levels of talent, not just someone that knows how to do investigations. Very often it's given to the head of security because he'd done 2 years in law enforcement. Leave it to him. That's not what you should be doing. What you need to be doing is creating a dream team. And that should involve someone with legal and procedural knowledge. Not every company has their own internal legal counsel, but quite a lot of companies have their own legal advisors they go to for advice on corporate affairs or contracts or whatever. Go and talk to them and say, we want you to be part of the team. How should we set that up? And later, when Christina joins in, she'll be talking about some of the issues that she's come across when we ask questions about how do we set this up, and having legal advice and legal input into the situation, because you can fall very foul of the law if you conduct investigations ethical and illegal, and you can do it very easily. The way I just demonstrated there with that case example of the CEO sending down his number 2 to go to the general manager's house and steal the laptop computer. That's illegal. It happens, and that's a true story. Someone, get them on the dream team that's got financial, business, and forensic accounting skills. Most companies have, of course, their own accounts department. Find someone within that department that you can trust and will work ethically and in confidentiality, and get them on the team. Information technology. We've come across cases in the past where very often the perpetrator, the suspect employee, has been given a laptop computer by the company. So the company owns the computer, has the right to access it. And when they've discovered wrongdoing, or there's been a whistleblower allegation or something of that nature, have immediately sent the IT guy to get the computer and start searching for emails and stuff like that. Traffic, data traffic. Wrong. Absolutely wrong. This, to get evidence from a computer, requires data forensic skills. So don't fall into the trap of just thinking the IT guy can get the information and the evidence you need. That's not usually right. You need someone that has some data forensic skill sets, because it is a specialized skill to remove, recover, deleted, overwritten data from the computer and produce it in a way that can be used as evidence either in a court of law or a labor tribunal. Investigative skills. This is almost like sort of, we're doing an investigation, so it stands to reason that it would be good if you've got someone on your team that's had some form of investigative background. And I'm not just talking about a police officer, for example. I mean, if people that actually do internal audits of that nature, legal, an inquiring mind, and someone that knows how to put facts together in a logical sequence and interpret facts and come up with a conclusion is really what we're after. Someone with that investigative skill set, that mindset is what we're after. Another important component, which is quite dear to my heart, is interviewing techniques. At some point in any allegation of significant misconduct, you are going to have to interview the whistleblower or the complainant if they're willing to talk to you. You're going to have to interview witnesses. And then at the end of the day, at some point, you're probably going to have to interview the person that's accused of wrongdoing. Interviewing is a skill. It's not a job interview type skill. It's interviewing to get facts in a sequence that's logical. And at the end of the day, when you interview the perpetrator or the suspect perpetrator, it's hopefully getting them to tell you how they did it. Remember what we said at the beginning? The modus operandi, how did it happen? Usually the person that's going to tell you that is the person that did it. Interviewing people like that is no easy skill. There are actually training courses specifically for this, teach people how to interview in what we call non-confrontational manner. And I'll discuss that a little bit later in the panel discussion. Strong analytical skills. As I said, usually the person that's good at investigations should be good at this as well. You want someone to put the facts together in a proper sequence of events and come up with the answers you need as to where the investigation should go and where it should end. So strong analytical skills. And usually, you're going to get that at a management level, because senior management that's making decisions about the business will probably likely be quite good at this as well. But that's what you definitely need in the team. And probably one of the most important is the administrative skills. Go back to that sample I just gave you. When we came in to take over that investigation, it was an absolute disaster. That investigation being run by the CEO was close to a month when we took it over. We couldn't find anything. Statements had allegedly been recorded. No one knew where they were, what date, time, and place they were, who it was that gave the statement. Items have been recovered. No one knew where they were. It was just a disaster. For a good investigation that's going to stand the rigors of legal analysis, a court, a labor tribunal, you have to have somebody that administers the investigation. That is, date, time, and place, people are interviewed. where you store and keep the exhibits, where they're kept, where you find them, where they were found. Invariably, you'll take photographs of a particular incident where it took place. Where are they? Who took them? You need someone that can administer the investigation itself. It's almost administering a project. Same thing. If you're doing a major project, a restructuring of your business, a refurbishing of a factory production line, you want someone that actually follows the process, who says where everything went, who's made the order, when will the machinery be delivered, who will deliver it, etc., etc. It's a similar approach, but we've come across so many times companies just launch into an investigation. It grows into something much bigger than they expected. No one can remember where things were put, who did what. It becomes something of a disaster, to say the least. So that was the dream team that we say you should consider, and it should be considered now, not later. Don't wait for something to happen and be running around like headless chickens trying to put it all together. Okay, that's the first part. The second part is any investigation you conduct has risks. The risks are either ethical or legal. It's massively important that management understands when they draw up a plan, put a plan together, that they understand the risks that are inherent in that plan. What are we talking about here? We're talking about avoiding needless risk to the business, avoiding needless risk to the company's reputation, avoiding needless risk to management itself, and of course to the employees. Some of the things that we've seen happen endanger the employees by asking employees to go and do certain things they should not be doing. We've had incidents, for example, where there's been allegation of collusion between a supply manager and the supplier, and the senior management have asked some of the employees to go and do surveillance on the company supplying the products. Well, they have no skill set for that. In certain countries, it's illegal. For example, in China, you can't go and do surveillance in the true sense of the word. So you have to be extremely cautious and be mindful of the risks that can be inherent in the plan. Minimizing investigative risk would therefore consider what is the goal of the investigation? What are we hoping to achieve? We must have crystallized what is the objective that we're trying to achieve with this. Second, once we've crystallized the objectives, are they lawful and reasonable? And if you don't know, then it's advisable you seek legal advice, seriously. It can go horribly wrong. You've only got to see it, some of the global headlines, particularly those that come out of the US, some companies that have conducted investigations, employed private investigators, and come very badly unstuck indeed, and CEOs have resigned. I won't name names on this broadcast, but there's been quite a few. Again, this leads into, can the information we're seeking be legally obtained? And again, in the panel discussion, we'll be touching on this particular topic. Next question, how do we know the facts available are correct, are true? And this winds its way back to the original informant, the original whistleblower, the complainant. In that case example I gave you again, that the CEO from the US flew in to Shanghai immediately. No one made any attempt to find out who the whistleblower was. Nobody made any attempt to verify what that person said could be accurate and reliable. They just knee-jerk reacted to the information and went straight for it. That's not what we're after here. What we need to know is the information we've been given reliable and accurate? Is there credence to it? Otherwise, we can get ourselves in serious trouble here. What is the information? What needs to be found, and how we're going to accomplish finding it? Again, this looks at the legal side of it, the ethical side of it, and we'll touch on that very shortly as well. And lastly, can we meet expected timelines of the investigation? Now, that may not sound that important, but we've done work for a hotel chain, shall we say, and they have upwards of 30 plus hotline complaints around the region a month. They have their own internal investigation team. And one of the issues that we got called into some time ago to deal with was the fact that these investigations were just running and running and running and never ended, because no one had set a timeline for the investigation itself. And these were ranging from petty misconduct right the way through to serious collusion between the restaurant managers and the vegetable suppliers, for example, which was thousands of dollars, a lot of money, each month. And there was no timeline set for the investigation. Senior management just let it run and run and run, which is no use to anybody. Because remember what I said before, you've got to, if you're a listed company, you've got to be mindful of the regulators and the time required by the regulators to get this done. It just goes back to the same thing again. If you don't plan, you're planning to fail. Hugely, hugely important. So planning for internal investigations. Like I said at the outset, in most corporation businesses, everyone knows their own part of the business. They're all very good business people, production staff, etc. But understanding how to conduct an investigation can be quite alien to many folks. That's why I said this thing about the planning, about setting up a dream team, making sure that the plan for the investigation is ethical and legal before you launch into it. When we conduct investigations, what we're looking at here, management must be mindful of the confidentiality nature of what's been taking place. The investigation itself, should we go overt or should we do covert? Should we keep it quiet for the time being? The confidentiality is very, very important. So the people that are running the investigation must understand confidentiality is vital. Proper mindset. When we proper mindset, what we mean is basically don't go in with prejudice into the investigation. So if you've got someone, say, from finance to be able to run the investigation, and finance doesn't get on with procurement very well, and their investigation and allegation against procurement, we don't want them investigating and going in, we hate procurement, we're going to get them, we're going to catch them this time. That's not the proper mindset. The proper mindset is any prejudice you have, any opinions are left at the door, open-minded when you go in and do it. And it's very important the dream team has that understanding. Professionalism is extremely important. The way you would approach business professionally must be the way you approach the investigation. Ethical and legal are the things that jump out every time. Independence. It's very important that senior management, if it's a significant misconduct activity, gives the dream team, the investigation team, the independence to run the investigation. We've had instances where a particular department or people in a particular department have been investigated. The manager of that department demands to know the progress of the investigation, demands to be kept appraised, demands to see the evidence, when he's not involved in the investigation. And if senior management don't go to that particular man and say, excuse me, Mr. Chan or whatever, Mr. Jones, leave this to the investigation team, we'll brief you when we're ready. If we allow interference, it will get sidetracked, information will get leaked out, it can fall apart very quickly. Serious consequences. Objectivity. Right at the beginning, we said that the investigation plan, what is the object of the investigation? The team must maintain the objectivity. They cannot be allowed to run off on fishing expeditions of what they want, what they think is important. It's what is dictated. What are the objectives? They need to learn to stick to it and must stick to it. Impartiality, when they reach the conclusions of certain sections of the interviews and certain sections of the evidence gathering, they do it in a way which is impartial. There can't be a case of, well, Mr. Smith in finance didn't follow the rules properly, therefore is involved in fraud. That's not impartial. Look, they must be allowed to look at the facts and the evidence and draw conclusions impartially. Okay, the final part of this section, my part of the presentation, before we open it up to the panel discussion. Competency, therefore, at the end of the day of all this, is the most vital part of what we're talking about. The individuals that you assign to do the internal investigation must have the experience and expertise to do the job. It is of no value if they don't understand what they're doing, no skill sets within this area of competency to actually fulfill their obligations. Training and qualifications are a very important component. If you're going to set up the dream team and you already say, right, these are the guys that we think should be involved in investigation when they start, don't just leave it at that. We actually say to companies, if there's a particular skill set that's lacking, get the people trained in it. And I talked about interviewing, that interviewing suspected employees of wrongdoing and putting it to them. It's no easy task. And so it's what we call non-confrontational interviewing. That's a skill set in its own right. And we do that as part of our training for some of our clients. And that's a 2-day training course to give the basics of how to do non-confrontational interviewing. And it's a very important skill set to have. So look at it, and if there's holes in the skill sets of the people, get them trained. They should have a working knowledge of the company policies and procedures. There is no point in investigating someone for misconduct of a particular policy, conflict of interest, bribery, corruption, excessive gift giving, or whatever it is. If the people doing the investigation have no idea of those policies, they've got to understand the working policies and procedures of the business if they're ever going to have any success at doing a professional investigation of misconduct. You have to understand the business as well, not just of the unit they're investigating, the person within the unit that they're investigating. If you're investigating someone that's been involved in fraudulent activity or corrupt activity in, say, the sales department, the bonuses that are being given out or whatever it is, and that's been fixed, and misconduct has happened within that system, you need to know that system and how it works within that unit. Otherwise, you can't succeed, no matter how good your objectives are. Unless you know how that part of the business works, you're unlikely to come out of this with any form of impartiality and understanding of what went wrong. And in due course, of course, not being able to help the business grow and avoid that problem in the future. Have an ability to understand a wide range of investigation techniques. There are significant. Statement taking is one, report writing is another, interviewing is another. There's a number of skills that the dream team will need at some point. Again, go back to the training component again and ensure that people are trained and understand how to use those skills and when to apply them. Massively important. There is no point in having a fantastic investigation plan, bunch of really good people doing the investigation, if no one knows how to put together a detailed report of what happened. Pointless. This is the final piece. Someone needs, and we went back to administration before. This is often the person that can put the report together with all the facts coming in. It's vital. Senior man, if there's been a serious misconduct allegations, senior management will want to be able to read the report that's clear, concise, accurate, and professional, and unbiased. And Christina will talk about this a little bit as we move on, about from a legal advice perspective, giving legal advice to a corporation, a company, about what happened and how you should proceed. If she gets put before her a horrible report that means nothing, that is very badly put together, the advice you're going to get will not be as good as it should be. And finally, and this is really important, and we're going to be talking about this in a second when we bring Christine into this and the show. Mindfulness of the various legal and ethical implications of the investigation are hugely important. I haven't touched much on it right now because we're going to talk about it in the next 20 minutes presentation. But this is a minefield. A number of companies have policies in place and procedures how you should treat your employees, and which is great. But it's the legal side of life that's equally important as the ethical. So that was basically, ladies and gentlemen, just a quick overview. This is a hugely wide subject, as you can imagine. What I want to do now is open up and bring in the two panelists with me, which is Christina with her law background, legal background, and Ashok with his corporate background. So if I could just take away the PowerPoint and bring in the team. There's Ashok. Christina, are you there?
Hi, everyone.
There she is.
Hi.
All right. Hi. Okay, quick introduction again. Christina is based in China, in Shanghai. She's a senior partner at Universal Law, offices in Shanghai. And she's an associate with Key Risk Consulting and helps keep us on the straight and narrow when we do work in China. So Christina and I have worked together 10 years plus on numerous cases, including the one I gave you an example. So she's well placed to give input in respect of the legal sides of conducting internal investigations. So welcome, Christine, again. And Ashok is he's our man of experience. He's been working in the compliance role for many years for a number of corporations around the region. I think that's correct. Africa as well.
Yep.
Yes, he's nodding away. Yes, we got him. And Ashok currently runs his own consultancy firm, which is ABMS, as you can see in the logo, which is an anti-bribery management company, and he advises clients on anti-bribery programs and structures. So to kick off the second component of the presentation today, ladies and gentlemen, I'd like to bring in Christina up first, if you don't mind, Christina.
Sure.
And what I want, one of the points I want to bring out for the audience, which I think it would like to know, is, the first point from a legal perspective of internal corporate investigation. And let's focus on China for now, because China, what happens in China can impact the rest of the world, and etc. So let's just focus on your bit in China. What do corporations come to you with in terms of internal investigation, the type of activity they seem to be concerned about? When they sit in front of you and say, Christina, we've got these issues, what should we be concerned about from an investigative standpoint?
Okay, Bob, thanks. So for corporate investigations, we think we're often involved one or more of the followings. So the first one, as Bob already mentioned many times during the presentation, is planning and conducting investigations to find out whether it's a misconduct or it can be a civil matters or even criminal activities. And then interviewing witnesses, victims, or suspected employees. Also locate, assess information and the persons, collect evidence to support the legal and other proceedings. Surveillance of locations or suspects, and in the end, prepare detailed factual and unbiased reports of the findings.
Thanks. You heard me say earlier on, towards the end of my part of the presentation, the PowerPoint, about reports. So is it right that you've sat down with clients who've given you reports of the investigation they've conducted, and they don't make sense, they're of no value to you? Is that something you'd say was a bit of a problem?
Yeah, actually, for the reports, not just the legal advice, and I believe also the government authority in charge of this kind of case, we usually prefer the reports which are open-minded, objective, and without personal opinion.
So basically, you say that you can't really give solid legal advice to a client if they haven't produced their investigation, their internal investigation, in a manner which is digestible on paper, in word form, basically.
Indeed. Yes.
Ashok, maybe I could bring you in, Ashok, with all your compliance experience. Would you say that was, in your experience, would you say that the reports that are produced are vital in management making decisions about what to do next, how to stop? Do you remember the slide I gave earlier on saying what is management's major concerns? And one of those things was, how can we stop this? It also must include, how can we stop it ever happening again? And of course, the report is, I would say, and I'm not sure whether you'd agree, is kind of important for that.
Exactly. Thanks for the great introduction. As you rightly said, report writing is an art by itself. And as the investigators, one need to understand the complete story of all the events that had led to this incident. And then the investigation has to be quite proper. And it all comes down to writing a proper investigation report, which will then help the top management to really understand. So one is writing the report, the other one is presenting the report. So it needs to have the right skill sets, and compliance and the legal team takes a lot of efforts to get every facts right when it comes to giving the report, because report writing is important, and also it is an important evidence when it comes to further proceedings.
Okay, thanks for that. Yeah, Christina, coming back to you with the second point that I scribbled down here when I was talking on my PowerPoint, was we talked a little bit on the PowerPoint that I presented about the risk, when the investigation risks that can be inherent if planning isn't done properly. As legal counsel, you're sitting there and someone from corporate walks in, management, and says, Christina, we've done this investigation, or we're going to do this investigation. What are the important risk issues you would tell them that can impact when they conduct internal investigation? What would you say? Well, okay, Mr. So-and-so, ABC company, if you're going to do this, look at the risk issues. And these are some of the things as counsel, I would think you should pay attention to. How would you approach that?
Senior corporate management, we think must remember at all times that private sector businesses are not law enforcement officials, or therefore they have no right of detention, entry to private premises, or seizure of other person's property. So you must never use threats, force, or bribery to abate the cooperation of an employee. And also, senior management must always ensure they conduct their internal investigations within the confines of the law. That is why it is so important that they start with an investigation plan so they can identify the risks at an early stage of the process. So if someone within the business instructs an employee to do something which is unethical or illegal during the investigation process, then we think serious consequences may result. But
so when I gave that example, where the CEO of the company told one of his lieutenants to go to the house of the general manager and get inside and recover and take the computer out without knowing if it was a company or property or not, because he was so incensed and believed that on that computer was evidence of this guy acting unethically and not in the interest of the business. That was kind of wrong, right? That was not a good thing.
Yeah, that indeed. So we like the audience here need to also keep that in mind.
Okay. Just going at one point you said that I'd like to bring in Ashok again. Now, Christian was advising Ashok about talking about China, for example, and the investigate, and she will talk about it. You both will talk about this in a minute about investigations in one country. We've come across in the past where corporates head office have actually done an investigation plan or strategy that will be adopted and who will be on the team. That's good. That's exactly what we advocate. However, what they didn't do was consider the law, the culture, and the ethical standards and accepted ethical standards in the other countries in which they operate. Now, you've had experience in regions where ethical standards, culture, law is like in the Middle East. It's a lot different than here. You know, would you agree that a one-size-fits-all approach is not really ideal?
Yeah, can I take this answer?
Sorry again?
Can I take the question?
Yeah, all right, let's try again. We must have broken up. Basically, what Christine was talking about was conducting work and investigations within the confines of the law. It's correct. But in corporations which have offices, operations in different countries, we've seen examples of where the corporation has written an investigation manuals, which has been very centric to the head office. But they've got operations in Africa, Middle East, China, Vietnam, or whatever. But it's always been a one-size-fits-all plan.
Correct.
And you've had experience as compliance in different countries. What's your comment?
Yes. So the question now is, is one-size-fits-all approach will work or not? Definitely, it's not going to work. Obviously, the business conditions and the rules and regulations across multiple jurisdictions are absolutely very different. So in that case, we should make sure that the policy that the company is adopting and the procedures that they are laying down is actually helping the local entities to perform their business obligations in a right manner. So rightly said, we can't have this one standard policy across every country that they operate. It needs to be worked locally. You need to involve the local management and the local team so that they are seen as a team to work in this exercise of identifying the right investigation process, procedures, and then making sure that the investigation that they do is getting the desired outcome that is for the company.
Okay, thanks. So coming back to you again, Christian, on like the third point I wrote down here is, again, the scenario of a client sitting in front of you, getting legal opinion from you in respect of the internal investigations. What are the principal areas of concern that corporations tend to have when they are considering undertaking these internal investigations? What the principal, we talked about the risk a few minutes ago. What are there's other areas of concern as well? You know, from a legal perspective, what concerns jump out from your mind as what's prevalent in these situations?
Okay, Bob, in my experience, and I believe also those of my colleagues working here in China, we invariably are required to give legal opinion, legal advice to our clients on matters such as, are they allowed under the law to conduct the investigation of their employees? Can they detain an employee they suspect of a criminal actor, such as theft or fraud? Can they search their employees' desk, workplace, personal items for evidence of wrongdoing? And can they compel a suspected employee to answer questions and provide a signed statement? Can they access an employee's workplace computer, as you mentioned, and their phone to search for calls and text messages? And also, is evidence collected by them capable of being produced before the court?
That includes labor tribunals, right? Same thing.
Yes.
Labor tribunals.
Mm-hmm.
I'm going to throw a curveball at you here. You mentioned about producing evidence in court and searching an employee's computer. I assume you mean that you can do that if it's a workplace computer provided by the company. But what about telephones? We often, this is a very common question we get, or a very common demand from a client, said that on the general manager's phone or the suspect employee's phone, there's going to be text messages. We want you to recover those text messages. What do we answer? That's always a sticky one.
Yeah, I think it's not just a computer, not just a telephone. It depends on whether the properties are, personal belongings or they are owned by the company. So if they are, for example, they are personal properties, then the company cannot just, simply seize their item and examine them. However, if they are company properties, then the company can take them back. But under this circumstance, the company need to be very careful when open their cell phone or the computer, as in most jurisdictions, there are laws and regulations in relation with the protection of personal data as well as cyber security. So we need to be careful and study case by case here.
Okay, so I think the key here then is case by case, right? Because if you're talking about maybe from a China perspective, but if you're talking about other countries which the audience come from on this broadcast, then it's case by case, right? Because there are certain data or personal privacy laws and regulations in place which could impact it. But one of the things we very often get a client gets excited about what's on the telephone and sees it, and the same as you, we always advise clients to talk to your legal counsel first. Because going back to what Ashok was saying about different jurisdictions having different legal provisions for these things, right, Ashok? You would say the same thing, I suspect. Yeah.
Right.
Yeah. Okay. I know we got about 5, 6, 7 minutes left, so let's plow through for a little bit, couple more questions which I had. And again, Christina, the fourth point which I want to push to your direction is something that I said is very, very, very close to me as an investigation, and that really is about interviewing. Okay. Interviewing employees is always going to happen. It's going to be vital, no matter what. I don't know about you, Ashok. Have you ever come across an investigation into a particularly serious misconduct and you've never had to do an interview of anybody. It's virtually unknown, I think.
That's a no-no. I think it all comes down to having the right policy and then the right methods and having the right team in place and having the right procedures. This is a mandatory thing when it comes to investigations. The most important thing is to identify what are we going to get out from this investigation. If you are able to answer this question, it seems to be very easy, but it is actually a very difficult thing. Once we're able to know what exactly we are going to do with this investigation, then it makes life easy for all those who are going to be involved. So we have to have that team. It is good to have a team mixed with business experience, mixed with compliance, with finance. And once you have a right team, then it makes life easy and the investigation can go as planned and you don't have any shocks in the life.
Okay. Yeah, I agree with it. So I'm going to throw another legal question at Christina on this one. So the fourth point I'm going to bring at you, Christina, is staying on the subject of conducting interviews, because I myself, I think I shocked, as I say, and I hope the audience agrees, that's such a vital part of any form of investigation. Very rarely will you ever do an investigation of misconduct, never interview anybody. And we'll talk about the whistleblower towards the end, I shop. That's your part. But as far as you're concerned, Christina, it's, again, I'm sitting in front of you as the CEO of the company. I've got this issue. We're going to need to do interviews. From a legal perspective, where's the minefield for me? Where's the risk that I've got to be careful of? From a legal perspective. You could mention the ethical if you want to as well, by the way.
So I think the first thing management must remember is that in most jurisdictions in Asia, so it is illegal for a private citizen to detain and compel an employee to provide a statement. So you cannot use threats, bribery, or physical force to ensure an employee complies with your demands to provide a statement. So that's why we always advise our clients to begin a statement from their employees with a side declaration that a statement is being provided freely and without any threat. And secondly, I think you cannot force or compel the witness to sign the statement. So this is also true of a statement being recorded from employees suspected of misconduct. And actually, Bob, I think we have experienced, this sort of thing firsthand. Perhaps you could just give the audience here an example of what we have experienced.
Yeah, many, unfortunately. Some good, some bad, some horrible. Yeah, an example, I think what you were talking about there, Christina, was we had a case a couple of 3 years ago where it was a German company, and there were commodities that they were selling around the region, and there was a whistleblower again that gave allegations that the head of this particular unit that was selling the commodities out, but was taking kickbacks to supply larger volumes of this particular product than was allowed under the company rules to any one distributor. And so we were called in to do the interviews. They didn't want an investigation because they reckoned they'd done it. It wasn't bad. It wasn't brilliant, but it wasn't bad. But what they wanted to bring us in to do the investigations of the suspected wrongdoer. And you might remember the case, there were 30 interviews we had to do on one day of all the staff involved in this thing. It's significant logistically, never mind just interviewing. And the main culprit employee I actually was interviewing, and it took me 5 hours to actually get him to confess to what he'd done. But the head of audit was a German gentleman, and he came in. He'd flown in from Munich, and he came in that morning when we'd started the interviews, and demanded to come into the interview room that I was using for the number one suspect, shall we say. And he just went crazy. He locked the door, and he basically said to him, unless you tell us how you did it and what you've got away with it and who's involved, you're not leaving. And that was like, oh, that's not good. And he was insisting. I think that's what you mean. That's not right. That's illegal. You have no right to lock the door and say you are not leaving unless you tell me all about it. It's just, that's what you mean, right? That's what you're talking. That's an example.
No, you can't do that.
Yeah, not at all. No, that kind of threw the whole thing. It took us to bring the suspect back talking to us. He just sat there and was almost in tears for about an hour. So that gives you an example. That's a graphic example of, I think, what you were talking about. So the whole thing about, as I said at the beginning or partway through, about doing interviews is not on the dream team. Is having someone that understands all these pitfalls, what you can and cannot do when you start the interview to do it. And it's as we say, we do that training, and it's a 2-day training course in itself. But it's important that you remember that, because that's the point where you're face to face with the human being. You're not mirroring the hard drive of a computer. You're not seizing exhibits. You're not seizing documents, taking pictures. This is when you're head to head in the most difficult part of the investigation. That's when you're talking to the person, the suspect. So that's something. But and we're going to wrap this up. But there's one bit I want to cover, and I want to bring in Ashok here. This whole thing of invest, as I mentioned, right at the front end, really invariably starts with a whistleblower allegation. And we found many companies do not know how to set up a whistleblower hotline. And Ashok, I think with your ABMS work, you've advised clients, a number of clients, a significant number of clients, on how you actually set up a proper hotline that forms the very basis of how the investigation invariably starts. So maybe for the last couple of minutes, you can round it off with an explanation to the audience of what they would need to do to set up a strong complaints ethics hotline.
So the first and foremost thing would be to get the buy-in from the top management and the board of directors. Setting up a hotline system is actually going to benefit the company. It will help them to kind of have more credibility, and it will actually improve the bottom line. Having a system in place will also help employees to be more trustworthy. Setting up a hotline is also lucrative. In US, for example, the whistleblowers are rewarded at between 10 to 30% of the fines that FCPA actually levies on the companies. Taking an example of 2018 FCA cases, 84% of new cases were actually initiated by the whistleblowers. And then the FCPA fined $3 billion, and 75% of that is coming from the whistleblowers. So it's a very lucrative one. That's this nice part of it. But if you don't have a whistleblowing system, what could all happen is employees can be not guided by the proper principles. They wouldn't know whom to trust, and these sort of things will be avoided if you have a system in place. Having a system in place is a big exercise. It requires top management, it requires compliance, it requires legal, and having it properly set up, making sure that it is up and running. You have the documentation trial, and then making it reportable. And when the reports comes out of this whistleblowing systems, or the management taking adequate actions or corrective measures taken. So it's a process which is actually the ISO 37001 is prescribing. And they have also released ISO 37002, which is a whistleblower ISO standard. So having these kind of ISO standards for compliance is actually going to help the organization to actually be one step ahead of all the issues that could come up.
Thanks, Ashok. That was a good explanation. Thank you. As I say, the whistleblower hotline is crucial in this whole process. But we're kind of running out of time now. We had a couple of questions coming in, so I'd like to just wrap up this section in that I think what comes out of this is that in this day and age, internal investigation capabilities are a must, especially when you deal with employees that are very aware of their rights, are willing to push those rights and use those rights. Reputations of the companies can be destroyed if they do wrong. There's significant legal issues that need to be addressed, as well as the ethical ones. But I think what comes out of this whole thing is quite simple. Failing to plan is planning to fail. Most corporations go about their business They look at risks in terms of contracts, expansion, buildings, and all this kind of stuff, that due diligence, if you like, and all that kind of stuff, to reduce the risk. I think it's very important that corporates realize, big and small, that if they're going to do this, if they're going to have to do investigations of misconduct activity, it's got to be done in a way that protects the business, protects management, protects the reputation, and very importantly, protects the rights of the employees. And I think if they get that right, and they plan correctly, using some of the techniques we've explained here briefly, then I think they'll be in good stead to actually protect their business significantly and do the right thing, basically, to put it straight. So with that, we've got a question here, which is a very good question, and it's basically it goes back to the telephone thing again, Christine. And it's basically is can we, let me think I get this right. Can we answer, if the company owns the telephone and provides the telephone to the employee, can the company demand to get access to the phone and extract the data from that phone? And we touched on it earlier, and I think we kind of both agree that it depends on the jurisdiction, and it very much depends on the case itself and the risks involved, and it's pretty much a gray area. I think, would you agree that it's something that needs to be looked at very carefully? So as mentioned, we've had these questions before in live when we're doing work, and we tend to do what Christina said. We'd ask the company to take legal advice first, even though you own the phone, because of the jurisdiction you're in, the company's ethics in relation to the privacy of the employees, and the benefits you'll gain from doing it, because it's a very big step. And I think maybe, Christine, you might agree with this. It's a very big step to take, because the phone is a very personal thing, even if it's supplied by the company, and lots of personal information sits on that object. Is the investigation worth it? So when you're planning the investigation, if it's an enterprise-threatening investigation or incident, if it's the evidence resides on that phone, and it's definitely on that phone, and it's crucial, then get legal advice straight away whether you can do it. If it's just a fishing expedition and you don't know what you're going to receive or what you're going to find, and you're just looking to find something, then because it's such an emotive thing, I would probably suggest don't do it. What do you think, Christina? What would your legal hat, what would you say?
Yeah, actually, Bob, I'm totally agree with you. So as mentioned, the contents within the cell phone or the computer, no matter if they are owned by the company or with certain employee, it can like contain their personal data or the privacy of this certain employee, or even related with a third person, or in some circumstances it can be related with national security issue. So we really need to be careful when we try to obtain the information from this device.
Okay, thanks. We just got another interesting question as well regarding when we do the interviewing. What happens if the person being interviewed refuses to answer the questions? Can he do that? And secondly,
of course,
can the interviewee demand having a lawyer present during the interview?
they can ask the legal counsel or to prison or civilian the whole process.
Okay, yeah, that's actually a good question. We've had that in the past. The first part is, if they refuse to answer questions, there's nothing you can do about it. You can't force them to answer. I think that's what we talked about earlier. You can't force them to answer. You can't compel them. You can't use any coercion. So you just have to write down on the paper when you're taking notes, he refused to answer this question. And that actually could be more damning to them than if they did answer it. Because if you said, Mr. Chan, did you open this ledger and put an entry in this ledger on such and such a date? I refuse to answer. That doesn't look good for him. He's supposed to be helping you as a company to do the investigation, but he's refusing to answer. that doesn't look good for him. So that may work against him in some respect. But no, you can't compel. That's the answer. But that was a good question. We get that.
Yeah, you can't compel the employee to make any statement. You can't compel them, force them to sign their statement.
Okay. Okay. I think we've finished our time now. I'd like to thank everybody for giving up their time and listening to us. You can reach out to us if you need any further information about what we've talked about or need any help with anything from the legal side, investigation side, anti-bribery side of life, and we're more than happy to help you anytime and talk to you on the phone, go through any questions you may have. But I hope you enjoyed that. I hope we came across with the importance of this thing. It's not something you just do, and it's annoying, it's a nuisance. It's an enterprise threatening activity if you get it wrong. And again, thank you everybody for your time, and thanks for BMCC for hosting this and putting it together for us. Thank you.
Thank you very much.
Thanks.
Thank you, Robert, Christina, and Ashok for the enlightening dialogue. And that brings us to the end of our webinar. Thank you once again to all of our speakers for joining us for an informative session by sharing your views and thoughts on today's theme. And our appreciation also goes to our co-organizer, Key Risk Consulting Asia, Sandhya Berhad. And thank you everyone for joining us today, and your feedback matters to us. So please complete the feedback form provided in the chat box if you haven't had the chance to do so. And goodbye, have a great day ahead. Thank you all.